Hello, everyone, and welcome to Cyril, Amarchand, Mangaldas, and Pepperdine University's joint event. My name is Sanjna Pramod, and I work with DLA Piper. For today's webinar, we have a very exciting and diverse panel lined up for you, who will share their international perspectives on mediation in 2021. Now, going around the virtual table for a quick introduction of our speakers. First, we have Justice A.K. Sikri, who is an eminent jurist and a former judge of the Supreme Court of India. He has authored over 4,700 reported judgments and now sits as a judge of the Singapore International Commercial Court. Next, we have Honorable Alexander Williams III, previously a judge of the Los Angeles Superior Court. Honorable Williams brings over 24 years of judicial experience and has served as an adjunct faculty for dispute resolution at the Pepperdine University for 15 years. Then we have Mr. Sriram Panchu, who is a senior advocate at the High Court of Madras and an internationally recognized mediator. Over the last 20 years, Mr. Panchu has been instrumental in bringing mediation into India's dispute resolution system. He is the director of the International Mediation Institute and is on the panel of several other institutions. Following this, we have Professor Joel Lee, is an associate partner with CM Partners and a principal mediator with and the training director of the Singapore Mediation Center. Professor Joel is presently the founding chair of the board of the Singapore International Mediation Institute. Next up, we have Dr. Sukhsimranjit Singh, who is the managing director of the Straus Institute for Dispute Resolution at Pepperdine University, where he also serves as an assistant professor and director of LLM programs. As a successful international mediator, Dr. Singh has resolved disputes across the US and beyond. Finally, we have Ms. Shaneen Parikh, who is a dispute resolution partner at Cyril Amarchand's Mumbai office. She has represented clients in domestic and international arbitrations under various arbitral rules and also specializes in commercial litigation. I'd also like to invite the audience to post their questions in the Q&A section. This session will be transcribed. Shaneen, I'll leave it to you to take it from here. Thank you.
Thank you. Thank you. I'm actually delighted to be the moderator for today's panel session as a part of MCI's ADR week in partnership with Straus Institute, Pepperdine University. The topic for discussion today is mediation in 2021, and we cover an international perspective, as you can see from the absolutely stellar speakers that we have on the panel. As a lawyer, more and more over the years, I have found that where there is a possibility of settlement, clients will take it, rather than expend energy and resources in a litigation or arbitration that could otherwise be avoided. As always, there are horses for courses, and it is not every dispute that will achieve a consensual outcome without going through an adversarial process. But certainly it is worthwhile to make a first attempt. Often, owing to heightened emotions and egos that sometimes abound in a dispute, parties may not be able to sit across the table and dispassionately discuss their issues. This is exactly where formal mediation or conciliation plays a big part. A respected third party can often lead the litigants towards a compromise. And I say so because human history is rich with the willing adoption of non-binding forms of ADR to resolve all kinds of disputes, whether in the mythical times of King Solomon or in ancient India when an informal council of village elders mediated a dispute, possibly under a large banyan tree. However, over the past century, with increased commercialization and globalization, the culture of dispute resolution has become not only more formal, but also contentious. And this may be expected when the stakes run into millions. Unfortunately, this is much too often fueled by pride rather than practical or commercial prudence. And this is where I see mediation playing a starring role, particularly when we find ourselves today in the middle of a global recession where there is neither the mental nor the financial appetite to go through a long drawn-out battle. In our panel, I hope we will shed some light on the effectiveness of mediation in different jurisdictions, and key to that is how to enforce settlement agreements. We will wade into the Singapore Convention, which is a game changer that has recently come into force. I end my introduction by borrowing a quote from Joseph Grinbaum, a noted American mediation professional and engineer, who said, An ounce of mediation is worth a pound of arbitration and a ton of litigation. And I hope that by the end of the session, you agree with that. Now, coming to the questions to my esteemed panelist. When one speaks of ADR, alternate dispute resolution, it is often a reference to arbitration, which is an adversarial approach without, of course, the formality of court procedure. The concept of mediation is sometimes relegated to a pre-contractual step, one to be simply tick marked so that parties can proceed to adjudication of their dispute. But is that still the case? Do our panelists think that in the world today things are changing? And so I ask first to Justice Sikri, then to Judge Williams, and then to Professor Lee. In your experience, is mediation treated as a pre-step or is it becoming a standalone process? Justice Sikri, may I come to you first?
Thank you, Ms. Parikh, and my good morning to all Indian listeners and who are at other places. It may be good afternoon or good evening. You rightly in your introduction mentioned about the uh, advantages or rather the spirit of mediation. And if I may add to that before coming specifically to the question, because that is the prelude to what I want to say, that in many circumstances which we have seen and witnessed, and all the panelists, they know fully well, all those who have gone through the process of mediation, they also know it, that in many circumstances mediation becomes a better form of access to justice, and it comes out with solutions which we cannot even think in adversarial system, whether it is court litigation or arbitration. There are so many other choices possible, and best thing is that it is the party autonomy, and the parties themselves, they self-determination, they think what is good for them, and that is why it is called win-win situation, and it is what is known as libertarian approach. And I remember Mr. Sukhinder Singh is here. He has written in one of his articles on the culture and access to justice, how in different countries, different cultures are there, Western countries vis-a-vis Eastern countries, and how it may lead to access to justice in the context of mediation. We can't go more into that. But what I'm trying to emphasize is that, look, when this is the spirit behind mediation, it is still treated as, particularly in India, but we'll come to what are the developments which are taking place. But it is still treated as pre-step to the court system or the arbitration. That look, okay, before we go to the court, let us try it, and if it happens, and that is also not in that form in which it is practiced in other countries. Actually what happens, and you have used the expression pre-step, but it may be a pre-step or post-step, but as an adjunct to the other system, like under section 89 today, when the suit is already filed under section 89 of the Code of Civil Procedure, court can refer. So in a way, although litigation has started, it is a post-step. But in contradistinction, under the Commercial Court Act, under certain circumstances, you have to go to the mediation first as a compulsory process before you come to the court. So it becomes a pre-step in that case. Having said that, and it is how it has begun in India. So there's no, quarrel about it and no qualms about it. But what I'm saying is that people are realizing, the stakeholders are realizing the indispensable nature of mediation and the merit which is seen in the mediation process. As you also said that in COVID, particularly when we don't have time also, we don't have money also, and mediation is such a fast-paced process which can be quick, resorted to, and the dispute can be resolved quickly. So therefore, it is time has come that when it becomes a stand-alone process in India as well, which has happened in other countries. If US is one example. It is happening in many European countries. It is happening now in Singapore also. And you see how it has developed in other countries. If I give you the example of community mediation, which is taking place in other countries, and private mediation, which we call. So where the two parties have a dispute, they won't think of going to court, but they are professional mediators. Private mediators are there. So like providing those services, institutions may be there. So they will say, let us go to that particular private mediator or that institution as we go to for arbitration, etc., for these institutions, and try to get the matter resolved there. So this is private mediation, which we say is a peacemaking in the profession, and the community mediation, which I would say about which we are also talking about a lot, and why it should not be there in communities, etc. And it is the recognition of both individual human dignity and social dimension of human existence. So when that is the purpose behind it, I think we are getting towards, in India also, the process has started. It is slow, but it has started, where it may become a standalone process over a period of time.
Thank you, Justice Sikri. I come to Judge Williams. Justice Sikri alluded to Section 89. That is Section 89 of our Civil Procedure Code, under which the court may refer parties to a mediation or settlement where it believes that elements exist. What in your experience, are you now finding that this is common? That do US courts refer parties? Is it common to have a standalone mediation process? We'd love to hear your experience and thoughts.
Well, thank you very much, Shaneen. And I really appreciate the Justice's remarks, because he points out how mediation emerges from the organic nature of litigation and has a role there. I think I'd like to look at the elephant from the other end for starters. In my life and in my professional life now, mediation is very much a standalone prospect. It is a function to which people have been sent with one goal in mind, and that is to settle it. Don't go back to that. Don't come back to my courtroom without this case settled. And so that there is that attitude about it. However, failing resolution, the mediation then becomes perhaps a first step or pre-step, but it has many, many values. It can clarify the issues, narrow the gaps, civilize the dialogue, foster optimism, foster teamwork, have a lot of values for the purposes of advancing the ball. So it can, if it fails to be successful in its mission as a single one-stop event or process, then it still offers great value to the participants. And because of its success, mediation is actually being baked into contracts now, baked into court rules, as the Justice was pointing out, and as you just pointed out, and therefore it now has a pre-step kind of look to it, because everybody likes it. Now, one of the problems I have to cite to you, and I was going to mention this in the second portion that I'll be speaking with you today, is that in the United States, we do not have one legal system. We have 51, plus the territories. I mean, and the answer is, at least we joke in this country, the answer to most legal questions is, it depends. Well, the answer to most questions about dispute resolution is, it depends. And you have Florida, where mediation is very regulated and very lawyer-centric. You have California, where it's easier to be a mediator than it is to be a cosmetologist, because there's no exam, there's no requirement, there's no license, there's no fee, there's no certificate, there's no nothing. And there's also no consumer protection. So that it varies. So I think that it is both a standalone process and a preliminary process. And that's part of the beauty of it, is the adaptability of the process. It brings out adaptability in judicial officers, in lawyers, and clients to get to their real needs as opposed to their procedural needs. I think I beat my time, but I'll be happy to. I'll yield it. I may need it next time.
Thank you, thank you. I'll come to Professor Lee, where Singapore, of course, has made huge strides, particularly with the SIMC and the ARB-Med-ARB procedure, which I believe has also become extremely popular and successful. So we'd love to hear your thoughts on this.
Thank you, Shaneen. And firstly, thank you for inviting me. And it's a little bit hard to follow two leading lights, such as Justice Sikri and Justice Williams, but I'll try. I think we have made some headway, and I think it's also actually with the cooperation of the rest of the world, really. I think the world has generally been moving towards mediation as a legitimate form of dispute resolution. One of the things I would like to say is that I know we typically say alternative dispute resolution, that's the original term that has been used and applied to things like arbitration and mediation. But I think the shift is beginning to happen into thinking about all the forms of dispute resolution as the appropriate form of dispute resolution. We can still use ADR. And it's more than just a semantic switch, right? Because if we start thinking about what's appropriate, then we can really turn our minds to saying, hey, sometimes arbitration is appropriate depending on your needs, litigation maybe, and maybe mediation might be as well. And so if we're beginning to shift people into thinking what is an appropriate form of dispute resolution, then we really can turn our mind to the actual question that meets the needs of our clients or our own needs, right? So that as a starting point, I think that's useful to sort of put out. The second thing is as to whether it is a pre-step or whether it is a standalone. To me, it is less important than actually parties and their counsel going in with the explicit interest of actually resolving it amicably. I think that's the key thing. So I know sometimes people refer to it as going into the mediation with good faith, or at least lack of bad faith, as the case may be, depending how you want to define that. But bottom line is parties and their counsel need to be open to the possibility of some kind of collaborative problem-solving resolution, rather than, and I think the intent of your initial question was whether we're just simply ticking the box. We've just done mediation, and therefore, it's okay now, we can arbitrate or we can litigate, right? I'm an optimistic person, and I know that around the world, various statistics are that about 7 out of 10 disputes that go to mediation, if there is sort of a genuine interest in resolving it, actually get resolved, right? There's some that don't, and that's fine, but not through lack of trying. Now, that 7 out of 10, I'm sure, comprise of parties who go into that mediation having already tried to solve the problem and probably sincerely believing that it cannot be resolved, right? Something happens in the hands of a trained mediator, of a skilled mediator, like my panelists here, who can guide the parties to seeing things that they otherwise might not be able to see, and therefore seeing a solution, right? So I think I'm less concerned whether it's a pre-step or a standalone, or it should be appropriate, is my first point. And my second point is that parties and counsel need to go into it with the right mindset. Going into a mediation with an arbitration or litigation mindset probably is not so helpful. Okay, it's a different way of thinking. All right, I'll shut up now, and if there's extra time, I cede it to whoever else might need it. Thank you.
Thank you. Thank you. I will move on to my next question, which is to Mr. Panchu. How efficacious have you found mediation really in resolving disputes? And from the Indian perspective, particularly since we have the Arbitration and Conciliation rather than Mediation Act, how is a mediated settlement agreement enforced?
Well, if you'd asked me this question in the 90s, I would have said everybody thinks mediation is very efficacious, because at that time people thought mediation was meditation. But very quickly, over the years, we've moved fast. We've had legislation in 96. We've had a huge court set up, starting mediation in 2005 and building it up over the country so that, in every court system now, we have court annex mediation. We have a few thousand mediators who mediate lakhs of cases. So we have driven mediation through the court setup. And that has given it a legitimacy and the backing of judges. Through that system, commercial cases have been mediated. A good number of commercial cases in a vast number of areas, business, banking, corporate issues, construction, finance, intellectual property, infrastructure. So these are now coming to mediation both through the court system as well as in private mediation, because now you have mediators who built up expertise, who gained experience, their training programs. So all this adds to the efficacy of mediation. The fact that it can apply to a range of disputes, which are big, which are small, disputes during court, pre-court. So the other important aspect of efficacious mediation is that you can combine mediation with arbitration and combine it very effectively. Again, pre-arbitration, during arbitration, and I've come across instances where right at the fag end of the arbitration, people request a mediation because at that time they know where they're strong, where they're weak, and they would like to see if they can settle the matter. So once you get actually parties to, the business of finding solutions, and as Judge said, it is solutions which matter to parties. And once they actually engage in that, once they look at their long-term interests, once they look at, get a little more realistic about their cases, how strong the case is, and once they get realistic about their options for settlement, which is what a good mediator will do. Once you do these things, then I think parties see that possible settlements are worth, much more than going on to endless and open-ended costly litigation. I find in India that two areas work very well: family business disputes, and many Indian companies are family-owned. And I find the disputes within the family are particularly amenable to mediation and are best resolved by mediation, because there is no other way really that you can treat that cocktail of, personal and professional and business linkages. The other, interestingly, is cross-border. And the willingness of Indian parties and foreign parties to sit down together to resolve an issue is again something I think which is noteworthy. So these are two good areas for mediation. I would say general efficaciousness depends on some significant players. The number of professional quality mediators. I think general counsel play a very important role, because the general counsel is positioned at the intersection of the company's legal requirements, the company's needs, and the law's demands. So he can bring to the table that crucial bit of detachment required to take an overall view of the mediation. So whereas in a litigation, general counsel is relegated more or less to the background, I would say in mediation, general counsel is very important. The other important, I think, player is a law firm, especially in commercial mediations. And there, I think, law firms would do well to set up a division with expertise, which can advise, which can be the advocate's role in a mediation, and which can monitor cases right in the beginning for an early evaluation of which is the best remedy. Too often I find cases go into litigation because many other remedies are not thought of. Let me quickly come to 4 factors which I think will drive mediation, and then I'll come to enforcement. I think the concept of pre-institution mediation is gaining ground in India. Starting from 2018, for commercial cases, pre-institution mediation, the concept that you must go to a mediation before going to court. While it hasn't taken off exactly in the manner we desired, but the concept is taking root, and that will drive mediation. We have a forthcoming legislation which is going to be comprehensive, which will cover court annexed, private mediation, cross-border, provide for institutions, and that will be a big factor. The third is online. Online will, I think, greatly add to the efficacious in mediation. And that's one thing which COVID has done amongst all the other amongst all our dreadful things. One positive thing is to show the efficacy of online mediation. So I think a lot of online mediation now is going to be, because you can synchronize schedules, you can synchronize dates, you do it much, much faster. And the fourth is the Singapore Convention, about which we'll talk later. So these are the reasons why I think mediation has now come to stay, why it is efficacious. In the area of enforcement, I would say two things. One, it makes, actually very few mediations actually go to court for enforcement. Most cases, parties just act on their agreement, because when you reach an agreement which is in your best interest, you implement it. So very few cases actually need implementation. In India, we had a bit of a, we've used the term mediation for court annex mediation. So in court annex mediation, you get a mediation agreement and the court will give you a decree. We've used the term conciliation for what I would say is really private mediation. So under the Arbitration and Conciliation Act, a conciliation agreement has a status of an arbitral award by consent. And the arbitral award by consent is enforceable by court. So we followed these dual models, of mediation for the court system and mediation outside the court system. But I think that is going to be resolved now in this enactment, taking a cue from the Singapore Convention and from UNCITRAL. We are, I think, going to use just the word mediation, and that should be ironed out. Thank you.
Thank you. Thank you, Mr. Panchu. Dr. Singh, your thoughts and the international perspective, and also just one very quick question. What happens to a mediated agreement that has taken place outside the auspices or outside the supervision of the court, in view of the fact that our act uses the word conciliation, and Mr. Panchu touched upon that? How is that enforceable?
Happy to. Thank you for having me here, Justice Sikri and Judge Williams. So wonderful to hear your comments. Professor Lee and Mr. Sriram, Panchu, such a nice auspicious occasion to be in your company. My comments first are geared towards just briefly on what is mediation, how mediation is helping us. Since I've had the pleasure or luxury of being in India and now based in US, but also traveled around the world, let me give you a global perspective. But before I go there, let me quickly say something about how mediation is a powerful tool. We have heard Justice Sikri mention access to justice. We've heard Mr. Williams mention goal is of settlement. Mr. Lee mentioned this appropriate dispute resolution process, not alternative. And Mr. Panchu mentions the efficacy of mediation, especially as it combines with arbitration. I want to talk about it very simply as three concepts. I think mediation is powerful, it is effective, and it is long-lasting. We teach at the Straus Institute mediation courses to hundreds of students every year, to dozens of judges and attorneys every year in our advanced training. And this is what we talk about. We say mediation is about economy of scale because you can impact many lives, but it's also about being economical, and both are important. We think mediation is life-changing. It is a process that is both internal and external. This thing hasn't been covered yet, so allow me to say a word about it. It is internal process because it has the power to reform you as an individual. So don't pick up mediation just because you want to do a high-end commercial case or help neighbor to neighbor or help a shopkeeper resolve a conflict with another shopkeeper. Also pick it up because it has a tendency and the power to change you to become a better human. And my colleagues will, I'm sure, agree or comment on that. Outside of it, well, before outside, I think part of what we have to remember is it is impartiality, the power of being present, the power of teaching to listen to others, and the power of being creative, standing on your feet and being creative. Which other process asks you to be excelling in all those 4 categories? So externally, if you go external, that is internal, changing you, right? Externally, I think mediation is wonderful because it helps parties to reach a satisfactory outcome, which is different than litigation. We can win in litigation. You may not win in mediation, but you can reach a satisfactory outcome, a long lasting. You can preserve a relationship. It helps parties to participate, right? Justice Sikri mentioned about parties process. Justice Williams mentioned that as well. The autonomy of parties is critical. It helps attorneys to articulate, to speak. It helps attorneys to be amicable, changing the culture of litigation. It helps courts, our dear courts that have done so much work. Let's talk about Indian courts. Our judges are heroes to be able to handle such a huge case load on a daily basis. It helps remove some case backlog, if not all of it. I think lastly, it helps society live a better life. So going to the question now of how mediation and vis-a-vis enforcement, I think it is prudent for us to understand mediation is for reconciliation, not always looking for a binding settlement. These are 2 different goals. See, to have something enforceable, let's be very clear, you need at least 3 different angles to enforceability. One angle is judiciary. If judges, courts accept mediation agreements that have been already signed, done as judiciously enforceable. Second is, it is based on parties and attorneys. So if they commit to the process and they think this is a good, solid process, then it's good. But lastly, it is the technical skills of writing a good agreement, which somehow we are overseeing. We have to teach in mediation how to write a good mediation agreement, which can be enforceable. Let me end by talking to you about how globally mediation has been changing or impacting. It is very different. Quickly, Japan, Kyoto International Mediation Center, Commercial Mediation Center, helped establish with the help of Straus Institute, has done some amazing work lately, but is very new. It's only a few years old, right? France is struggling still large time to enforce mediation because the society has not accepted mediation as an enforceable mechanism. Situation is very different in England and in Italy. In England, we all know London Court of International Arbitration really put forth the whole fact that dispute resolution is the future. And that propelled mediation being accepted as a very good, appropriate means. Italy, my friend Leonardo D'Orso and his company ADR World and Giuseppe Di Paolo's work in promoting mediation has even led to a legislation being passed that almost every case belonging to a certain amount in commercial cases must go through mediation. Same last country I'll mention is Brazil. Do you folks know there are more cases pending in Brazil by some estimate than the number of people living in Brazil? There is some terrific work being done by my colleagues in Brazil, like Marcelo Rosadilla and others, that talk about how we can, at grassroots levels, implement mediation without having to worry about, is it going to be enforceable or not? So I want to lay out the ground yet, but I'll come back and talk a little more about how Singapore Convention has impacted the enforceability and other aspects to it. Thank you.
Thank you. Thank you. So I noted that you said that in mediation a party may not win. And that reminds me of the saying that a successful settlement is one where neither party is perfectly happy. But I think what you're saying is that the key is that they are satisfied with the resolution and the outcome. I think that is really, really the point of it all. I move back now specifically to the 2 learned judges on our panels to ask for their thoughts on the effectiveness of mediation in resolving conflicts, both within the United States, and I come to Judge Williams first, and then to Justice Sikri.
Very well. Well, thank you. The simple answer is that the literature seems to be fairly uniform, that when we started a serious mediation practice in the United States in the last couple of decades of the prior century, that the success rate was in the 70, 75, sub 80 range. The sense now is that the success rate is in the 85 range. Now, I'm talking about a very parochial area, and that's my area of litigated cases. Mediation, one of the things I love about the Straus Institute at Pepperdine is we are not lawyer dependent. We are in a law school, but we are proud to train an awful lot of mediators who have no desire to be a lawyer, but have other things to bring to the table, because certainly the world needs some peacemakers. What I found myself intrigued about was reflecting quickly, if I may, on what makes for the success rate to be good or bad, what factors involved. And I think there's a number, and I'm just going to throw them out very quickly for purposes of putting them in the soup to be considered if anybody else wishes to. The nature of the mediation, is it court connected? Is it court conducted, such as a settlement conference, which some states call a mediation and California does not? And believe it or not, it has different consequences. It's crazy, but it has different consequences for confidentiality. Or is it private? Is it compelled or voluntary? There were people who told us as judges we shouldn't compel mediation because the success rate was only 50%, whereas if it was voluntary, it was 75%. Well, what did judges hear? Judges heard that if they forced it, they'd get 50% of their cases settled. So the argument was somewhat self-defeating, but at least that's the thought. Sometimes the area of law matters in terms of statistics. Everybody understands the history of labor law going back to the union movement, and those are very specialized areas. However, in the area of both family and probate law, we've seen the emergence of something called collaborative law. They really are in the vanguard, and it's a very specialized practice. Most mediators in those fields advertise themselves, at least in California, as being involved in those fields. A lot has to do with the legal culture. It was revolutionary when a very conservative Chief Justice, Warren Burger, in 1984, called upon lawyers to become healers of conflicts. I didn't hear that in law school 50 years ago, I can tell you that. And that is, so that's part of the culture. However, I have to tell you, when I was interviewed by the local legal newspaper, when I was on the court, and we talked about all the cases I was settling, they asked me when was the last time I tried a jury trial. And I love jury trials, but I told them I hadn't tried one in a year and a half. My presiding judge was not happy with me, because that's how he measured judges, is how many cases are you trying, one at a time, at a time, at a time, taking weeks as opposed to one day. So the culture didn't sink all the way down sometimes. Legal education matters. 50 years ago, I went to law school, 3 years, I never heard anything about mediation. I took 3 separate bars in 3 separate states, because that's what we have to do if you're in different states. Nothing about mediation. Now we have the Straus Institute, where I work with or for Dr. Singh, which is a fabulous place and a fabulous family of peacemakers, and other programs around the country. I've even heard it suggest that civil law systems may be less needing of mediation than common law, because civil law at least attempts to codify the law and give you more certainty than you may have in a world of precedents. We have only one civil law jurisdiction in the United States, that's the state of Louisiana, and I've rushed to assure you that everything is different in New Orleans. So it's a very different place. In terms of, I think that's just about it. One thing that is interesting, I do focus on, and when I teach and when I work with people, that settlement is not an event, it's a process. And my job is to try to make that process occur inside today's event. But if it doesn't, I'm not going anywhere. I tell people I will not quit on a case unless they get a restraining order or shoot me, because it's going to take the time it takes. And the one final point I would make, and this is anecdotal among mediators with whom I work here in Los Angeles, we actually think we are doing better, being more effective on Zoom than we were doing face-to-face. And that's heresy. You know, a year ago when we had to pivot overnight to this model, but it is a very effective device by many measures. Thanks.
Thank you, Judge. That was fascinating. And I know Justice Sikri is going to have some comments on what you just said. And we'd love to hear your insights, Justice Sikri, from your time on the bench.
Thank you, Ms. Parikh. Let me tell you, as far as India's experience is concerned, In 2002, Section 89, of course, as Sriram Panchu said, 1996, when the Arbitration and Conciliation Act was passed and the conciliation provision was introduced in the mediation, this Arbitration Act also. But the paradigm shift was with the introduction of Section 89 in CPC, which was in 2002. And I always say, I thank Salem Bar Association, which filed the petition in the Supreme Court challenging the virus of Section 89. Because had it not come to the court, like many other pieces of legislation, it might have been gathering dust somewhere. But by bringing it to the Supreme Court not only dismissed that, but the Supreme Court took it upon itself to now carry forward this movement and of mediation and to ensure that Section 89 becomes a reality. So to that extent, so the courts have played a very, very important role. And MCPC, which we call in the Supreme Court Mediation and Conciliation Project Committee, was constituted. First pilot project started in Delhi with the T. Hazari Center was established in T. Hazari. The Supreme Court had invited people. I still remember trained mediators from the trainers from US who gave training to Indian, at that time, district court judges. Thereafter, it was given to the lawyers as well. But I think they were following the Californian model. And here also, so it started with those judges. But one thing good, and within few months, I think in Madras High Court also, and Sriram Panchu was the main person who established that center. And I just now noticed Chitta Narayan saying on this chat that today is the 16th anniversary of the opening of the Madras Center, or Mediation Center. But so look, in 16 years, where we have come up to. And in first center, which was set up in that I told you about T. Hazari, the lawyers boycotted it. The lawyers at that time protested. They thought that with the coming of mediation, as if their practice is going to be taken away, which I always say, ADR was perceived as alarming drop in revenue for lawyer, alarming drop in revenue ADR, rather than the alternative dispute resolution. But in these 15, 16 years, the way the psyche has changed, the way acceptability has come, which Sriram Panchu also mentioned, this that we have made really big strides, no doubt about it. And I was just thinking when Mr. Sukhsimranjit was mentioning that there's something common between two of us. I saw his article, as I mentioned, on culture and access to justice. I had written one article that mediation is the best form of access to justice under circumstances more than 10 years ago. Then he just now talked about the mediation making us good human being. I had written one article exactly on this, maybe that also almost 8 to 10 years ago, where I connected mediation with spirituality. So how it is so close to spirituality. And therefore, what I am saying is, before coming to the effectiveness, that these are the aspects which are to be seen. It is becoming a real model for access to justice. It is making the life easier, more comfortable, by making all those who are involved in the process of mediation, by making them better human being. And about a couple of months ago, I had written another article where I had said, time doesn't permit to give a details of that, but I said mediation today is becoming a savior. It became a savior of this system in US, of the court system, because initially it was thought that we are burdened with so much of arrears, so something should be given to alternatively, and that let out should be there. Of course. So in that sense, and by making, resulting into settlements, which settlements, once it comes, another thing which is to be seen is no appeal, because the parties have settled the matter. So it takes care of the appellate court's load work also indirectly. And so therefore, and not only that, it is becoming the savior of even the arbitration process, with med, all these processes which are, and why mediation is introduced by all arbitral institutions to save arbitral. So therefore, this is the effectiveness of the mediation, which in the entire legal system or dispute resolution system, which we have to see. Now, I tell you from my personal experience, in last 2 years after my retirement, I was sent 6 cases, 4 from the Delhi High Court, 1 from Supreme Court, and 1 even from NCLAT, National Company Law Appellate Tribunal, for mediation. 5 were settled by me. 1 I could not settle, but as Sriram, Panchu also mentioned, where 80% or 90% was settled, but there was some difficulty, they were not, but when they went to the court, it got settled immediately on the basis where the settlement was going to take place. So therefore, that is the process of effectiveness, even when it results in the failure there, which has to be seen. And my experience is that when it comes to family matters and Section 89, or I give you another example from my experience only, when I was sitting in Delhi High Court, and in family matters, when suppose it's a 498A case, and say a criminal complaint is filed, and the husband comes or the family members come for anticipatory bail, etc. We used to do in High Court, okay, we'll grant you for some time, but in the meantime, go for mediation, even in those cases. And my experience was, for the time I sat, 8 out of 10 cases used to be settled. And commercial also, which Mr. Sriram, Panchu said, from I can say from Delhi High Court and in district courts, 50 to 60% cases are settled. So it is showing effectiveness there also, but it has other distinct advantages, which I said. So if we keep in mind all these aspects, then it is becoming effective. Only one area, and I'll take, because I know I've overshot my time, I'll take a few seconds, where we need to concentrate and have to find the solution is where the government is the litigant. Because for various reasons, fear of CVC and fear of audit, etc. Many times, even when they feel that the case should be settled, they are not coming forward. But of course, there are solutions for that also, which we can discuss. But this is one area which we have to see in order to make it more effective in a country like India. Thank you.
Thank you. Thank you, Justice Sikri. We now move across the world to Singapore. So the year 2008 brought to us the Singapore Convention, which is, I think, a game changer. The convention's purpose is to provide a comprehensive and uniform framework for cross-border enforcement of international settlement agreements resulting from mediation. And it is thought that the convention could do the same for mediated settlement agreements that the New York Convention has really done for enforcement of arbitral awards. And I think we just have the 168th signatory now to the New York Convention. So coming to Professor Lee, what are the benefits of the Singapore Convention, and how do you think it is going to impact mediation?
Great. Thanks for that. For those of our friends who may not know, Singapore Convention on Mediation, which was signed in 2019 and came into force in 2020. I think there are 2 main benefits to this, and one is practical and one is symbolic. And if you don't mind, if I actually sort of split it into those 2 forms. In terms of the practical considerations, Shaneen, as you've already said, the intent is for the Singapore Convention to do for mediated settlements what the New York Convention has done for arbitration, right? And the thing, if you actually do a comparison, I believe the New York Convention was signed in 1956, if I remember correctly, and SCM, of course, in 2019. Just the amount of signatories on day one is actually significantly more than what the New York Convention had at that point in time, although obviously that number has grown since. And I believe the New York Convention was a significant positive push in the direction of promoting arbitration, the use of arbitration in international disputes. And so the hope then is that as more and more countries, and this will take a little bit of time, so people can say right now, oh, it's only this many countries and so on and so forth, but it will take time for countries to sign and ratify. But the rate at which this will happen will be faster, I think, than the New York Convention, right? When there is a critical threshold, and I believe there will be fairly soon, what it actually means is that a mediated settlement in Singapore can be easily enforced in another signatory country in much the same way as an arbitral award can be under the New York Convention, right? Right now, what we're faced with is either it's an arbitral award under the New York Convention, or we sue on the contract, or we get a consent judgment and then enforce a foreign judgment, and so on and so on. So it's a little bit sort of niggly. It's not as easy to do. But once you have the CM and it comes into full swing, and people have sufficient people have ratified it, I think the impact is quite going to be quite significant, and that's the practical impact. It actually gives people the security that the form of dispute resolution they pick, mediation, has some kind of real impact. Okay, I think Mr. Panchu had said just a little bit earlier that in the old days, I mean, most of the time people comply with their mediated settlements because they're empowered, they were involved, and so compliance is usually built into that process. But there will be a small number for which compliance becomes an issue, right? And so, in a sense, you could say the SCM, Singapore Convention Mediation, gives sort of mediated settlements a little bit more teeth, a little bit more firmness, a little bit of enforceability, and that's the practical consideration. The symbolic consideration or the symbolic benefit of the SCM, I think, is twofold. Number one is it puts mediation out there as a real, legitimate, and valid form of mediation, of dispute resolution, right? Up till now, everybody goes, yes, arbitration, great, litigation, great, and all kinds of stuff. But mediation, well, that's kind of like mediation, right? Some people will even say mediation is not binding. Actually, that's not true, right? Mediation is binding if you have a deal, it's a contract. Now it's even more binding, right? Okay. The only difference between mediation and arbitration is where we say the mediator doesn't deliver an award, doesn't actually bind the parties with an award. But if there's a contract, that's a contract. It's enforceable, and therefore now equally enforceable under the SCM. So it legitimizes mediation, right? And then the second symbolism, of course, is that the moment that this is legitimized, it gives a rallying flag for all the mediation professionals in the world, all of us converts, all of us people who have been promoting mediation all these years, to basically rally behind and say, hey, hang on a moment, this is a vindication, this is a validation. And for someone like Mr. Panchu, I know, who has been pushing mediation for years, without necessarily acknowledgement, without necessarily validation, I think this is an important thing. This is a part of the fruits of your labor, and I think this is why the SCM is particularly important, at least for both Singapore and for the world, and for mediation. I'll shut up now. I think I'm still within time.
Thanks, Professor Lee. Mr. Panchu, India was one of the first signatories to the convention at a very glamorous ceremony in Singapore. How do you think the convention is now going to fit in with India's new thought process and the new bill that has come out? And when can we expect it will be ratified? I've put you on the spot there, I know.
Well, so the answer to that, you should have invited somebody from government. I hope soon, because India was a very positive about the convention, as one of the earliest big countries to join, and I think India's coming on board was a big fillip for the convention. I think the convention is important because it's like a seal of confidence. It is a seal of confidence on the part of the government, acknowledging the movement that has been made in mediation. And with now the forthcoming legislation, that mediation is very much, it's very prominent on the legal landscape in India. It's also important as a seal of confidence for industry. Because as much as one talks about, time and cost, and parties' participation, all of these are very beneficial to parties, no doubt, yes? and that you're engaged in getting solutions, etc. You still have that kind of missing element. You know, how much of this is enforceable in a global context? That global context is important. It is not sufficient, I think, just to focus on a domestic setting. And what the Singapore Convention has done is to give us that global context, to point to it and say, here it is now globally accepted. And I think with that, you know, every box is ticked off as far as the acceptability of mediation is concerned. Combine that with the fact that now, you know, you have professional mediators, it's a growing number, the success stories are growing. So now you have a profession coming up, you have good training coming up, you have a world stamp on it, you have governmental support, you have legislation which is going to come in. So it's a very positive, you know, overall situation. Focusing specifically on the convention, I would say one very important thing is it uses the word mediation and says all similar processes are covered by the convention. Therefore, there's this big problem we've had, you know, between conciliation and mediation. Are the two processes different? Between using multiple terms, you know, all that has gone now because UNCITRAL earlier used to use the term conciliation. And now they've recognized the worldwide trend towards mediation and said we'll just use mediation comprehensively. So that's a very big step. The singular system of enforcement for evaluating and enforcing, good. As I said, you know, our coming in there is going to do very well for our ease of business and to retain investor confidence. Because any other method of dispute resolution, you know, foreign investors always feel they're at risk. So the fact that mediation is growing in India, has been strongly adopted, and that these settlements are going to be enforced, will, I think, boost investor confidence. So on that ease of business, I think that's another particularly good point. The fourth point I want to make is, because the convention does not provide a seat for mediation, it permits online mediation. And therefore, it will cover online mediation. And that's, again, I think the convention was brought in before COVID. But I don't know, you know, this was a happy, you know, occurrence that the seat of mediation is not covered. And therefore, we can work online through that. The other is that investor-state disputes can also, I think, now come in through the convention. So it's up to us, I think, to draft a robust law, because that's what the convention requires nation states to do, to draft a robust law in line with the convention. And we have said that, I think we're done as far as mediation is concerned.
I may only add for your information, good thing is, as Mr. Panchu rightly said, we did never know, and that's a question to be asked to the government when it is going to come out with legislation. But one development which has taken place is that NITI Aayog started the project on ODR, online dispute resolution, in the wake of a pandemic. And in the report, they have highly recommended the passing of this legislation as early as possible. So coming from NITI Aayog to the government may, I think, speed up the things. Let us hope.
One hopes. Okay, thank you. I now come to Sukhsimran for your thoughts on the convention. I know you were there and involved with it, and also for your general comments and closing. Sukhsimran.
Thank you. Well, I absolutely, thank you, Ms. Parikh. I would love to. I'll be very brief, folks. I'll try to be brief. And such a wonderful, I love this, the quote unquote seal of confidence that Mr. Panchu spoke about, or quote unquote legitimacy of the process that Professor Lee spoke about the Singapore Convention. I'll give you two positives and two things we still need to work on. Let's not get too happy with the convention. There is a lot of work needs to be done. let's quickly summarize where we are in good things with the convention, right? First of all, what hasn't been mentioned, I want to mention that, and that is Asian culture has been given prominence. The fact that Singapore got to be the chairperson behind the conference is a big win. And we should not under-recognize that fact. The fact that one of the most diverse places on earth is Asia, and beautiful cultural traditions, different ways of resolving conflict. India has a whole Sanskriti of how conflicts can be resolved. Ramayana discusses how to resolve conflict that we have to explore. We have to see how our religious principles teach about resolving conflict. So things that needs to be explored can be explored because it happened in Singapore. 2, I love the fact that the convention gives international recognition, as Mr. Sriram Panchu was mentioning, about online dispute resolution or bindingness or agreements. So that is terrific. That is great. But here is 2 things we need to work on. Number 1, let me remind everybody, we are in a very divided time. All over the world, we have fights going on, we have strikes going on, we have people looking for their rights. We have people who are being killed just because they're speaking up. We cannot ignore that fact. Human beings are divided more, if you may, than ever. And maybe information technology is helping us realize that that's happening, but it is happening. Mediation has a role to play. The convention is not going to resolve it itself. It, as Mr. Lee said, gives it recognition. Mr. Panchu said, gives it the seal. We have to take it forward. My last comment, we have a lot of work to do in terms of let's not commercialize mediation throughout and let the convention take care of commercial cases and be a success in it. What about all the regional cases, cultural practices, those beautiful ones with some villagers somewhere in India could be knowing how to resolve conflict? Will that be recognized by the convention? Will that be ignored? In some ways, the government of India is taking time. Let's not jump on it saying that's wrong. I want to always give benefit of doubt. Maybe they are thinking through this. Let's hope they are. I want to thank everybody for coming here today. First of all, I want to thank our host, our moderator, Miss Shaneen Parikh. She has so kindly, you should see her resume. We haven't introduced her, but she is one of the leaders in Indian, not only legal industry, but Indian dispute resolution industry. She has done some phenomenal work in arbitration. So ma'am, first of all, thank you for your humility and for bringing us all men together and giving us the dais, whereas you stood back and allowed us. So thank you so much. Thank you. I quickly, thank you, ma'am. And I quickly want to thank Neeti, Miss Neeti from MCIA. She's been throughout the warrior and she's done so well. And of course, Mr. Madhukeswar, who is leading the institute in Mumbai. And because of him, we are here together. Last but not the least, quickly, Justice Sikri, thank you for all you have done, all you're doing, and all you're going to do. We can't wait to see, sir, what you bring next, your passion and your writing. I am going to read your article on spirituality. Thank you for mentioning it. Mr. Williams, Judge Williams, you've been a force for Straus. And sir, thank you for taking time. And I know it's 10:30 p.m. in US, and thank you for giving us your time. And I know your work in the morning. I really appreciate it. Mr. Lee, thank you for leading the efforts in Singapore Convention. I know you were backbone to all the efforts and you've been an amazing teacher. So thank you for all you're doing for mediation. And last but not the least, Mr. Sriram Panchu, you are a model for young mediators worldwide. With this, I will respectfully ask the organizers to conclude.
Thank you so much, Dr. Singh. I think you took the words right out of my mouth for your brilliant concluding remarks.
You spoke for all of us. You spoke for all of us.
Yes, I would completely agree. And I have nothing more to add, but just to say that wraps up an excellent session and has given us all a lot of food for thought. A big thanks to such an illustrious panel who shared their rich experiences with us. And thank you, Shaneen, for brilliantly moderating the panel across multiple jurisdictions. I know it was no easy task. And thank you to the audience for your enthusiasm and for tuning in. Before we drop off, the next session for the day, which is on arbitration and litigation funding, is hosted by Ainsworth Advisors and starts at 12 p.m. IST. So please do tune in. And thank you all for joining us again.